Welcome to the Truth About False Confessions podcast. I'm Alan Hirsch, chair of the Justice and Law Studies program at Williams College and an expert on false confessions. To learn more, visit my website, truthaboutfalseconfessions.com. Now on to today's episode. I am often asked how I ended up in the field of false confessions. The answer requires going back almost 4 decades. After graduating from Yale Law School in 1985, I worked as a law clerk for Judge Edward Becker on the United States Court of Appeals for the Third Circuit in Philadelphia. The U.S. Court of Appeals is one level below the U.S. Supreme Court, which meant some of the cases I worked on eventually found their way to the top. One such case had gone up to the Supreme Court and then back down to Judge Becker's docket shortly before I joined his staff. It was a grisly case. On an August morning in 1973, 17-year-old Deborah Margolin sunbathed on the porch of her home in rural New Jersey. A stranger drove up and informed Deborah that he had seen a heifer loose at the bottom of the driveway. He offered to help her retrieve it. Deborah declined the offer and proceeded alone in her brother's automobile in search of the animal. When she failed to return by late afternoon, her family began searching for her. Her father eventually found Deborah's lifeless body in a nearby creek, her throat and breast slashed. Summoned to the crime scene, troopers and detectives took a description of the stranger and his car from the victim's brothers, who had seen him drive up. One of the cops immediately thought of Frank Miller, a ne'er-do-well who lived in the neighborhood. Miller had an extensive criminal history, and his automobile fit the description. The officers drove to the plastic shop in Trenton where Miller worked the night shift, and Miller agreed to accompany them to the police station. After an hour of interrogation by Detective Charles Boyce, Miller broke down and confessed to murdering Deborah Margolin. Or perhaps I should say confessed and broke down, since after acknowledging his guilt, Miller passed out. At trial, Miller's attorney argued that the confession should not be allowed into evidence. Under Supreme Court law, a confession is admissible only if obtained lawfully. This means 2 things. First, if someone is considered a suspect when questioned, he must be given the Miranda warnings made famous by television's cop shows. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to speak to an attorney and to have an attorney present during any questioning, etc. Detective Boyce read Frank Miller these rights, so that was not an issue. The other requirement is more slippery. A confession is also inadmissible if involuntary, meaning if the suspect's will was overborne by the police, whatever that means. It didn't mean much to me. I was fresh out of law school and brought with me little real knowledge. I spent the first few months at law school learning my way around the library, and the next few years gaining a rudimentary understanding of various areas of law. I'd taken a single class in criminal procedure, where I learned that criminal defendants frequently claim their confessions were involuntary, but that courts routinely reject such claims. Which made good sense. The voluntariness issue reminded me of Bill Walton, the basketball star who suffered from defective feet. Many injections of painkillers enabled Walton to lead his team to an NBA championship, but cut short his career. Walton sued the team doctor, among others, who prescribed and administered the injections. The lawsuit settled, but I thought a single observation by one of his teammates demolished Walton's case. I saw the needles, but I didn't see the chains holding him down. Ditto all these criminals who complain that their will was overborne by nasty cops. No one made them confess. No one made them talk at all, and they were specifically warned that talking might get them in trouble. Having decided they could withstand an interrogation, what gripe did they have when their confidence proved unjustified? And why should we care anyway, since these people were typically guilty of heinous crimes, as they themselves admitted? That was my assumption as a law student. Now that I was a law clerk, the real world entered the picture. Detective Charles Boyce's interrogation of Frank Miller was audio recorded, and Judge Becker, my two co-clerks, and I listened to it in chambers. On the surface, most of what Boyce did seemed non-objectionable. Boyce actually acted friendly towards Miller and never raised his voice. He asked Miller to describe his activities that morning, then politely pointed out discrepancies and laid out incriminating evidence. When Miller maintained his innocence, Boyce shifted gears. He told Miller that he knew he was guilty, but that he wasn't really to blame because he lacked a criminal mind. He had a problem for which he needed help rather than punishment. Boyce gently asked Miller about the psychiatric treatment he received after a prior conviction, then ratcheted things up. Frank, if I promise to do all I can with the psychiatrist and everything, and we get the proper help for you, will you talk to me about it? When Miller stammered his innocence, Boyce said, I know what's going inside you, Frank. I want to help you. You've got to come forward and tell me that you want to help yourself. I want to help you because in my mind you are not responsible. You are not responsible. Boyce's ploy worked. Miller acknowledged the role in the murder of Deborah Margolin. At first, he insisted that some stranger committed the crime in his presence. Boyce persisted, repeatedly telling Miller, in soft, pleading tones, noted the Third Circuit opinion, that he could be helped only if he confessed. And he all but promised that a confession would indeed bring about help. We're going to see to it that you get the proper help. That's our job, Frank. That's our job. That's what I want to do. By sending me back down to prison, Miller protested. Don't fight it because it's worse, Frank. It's worse, Boyce replied. It's hurting me because I feel it. I feel it wanting to come out, but it's hurting me, Frank. You're my brother. But you gotta be completely honest with me. I'm trying to be, but you don't want to believe me, Miller insisted. Before long, Boyce tried another tack. It may have been an accident, he said. Isn't that possible, Frank? Isn't that possible? Miller responded oddly, Sure, it's possible. Boyce said, It may be something that you did that you can't be held accountable for. That is, I can help you. I can help you once you tell me the truth. This is the kind of relationship we have, but I can't help you unless you tell me the complete truth. It could have been an accident. You've got to tell me the truth, Frank. I can't help without the truth. I don't think you're a criminal. You have this problem like we talked about before, right? After 58 minutes of interrogation, Miller confessed to being the sole murderer. As noted, he then passed out. Miller's attorney's efforts to keep the confession from the jury failed. The judge ruled that he had confessed voluntarily. Miller was convicted. After that, courts played ping-pong with the case. The New Jersey Court of Appeals reversed Miller's conviction on the ground that the confession was involuntary, but the New Jersey Supreme Court reinstated the conviction. When Miller sought a writ of habeas corpus, a federal court got involved, but agreed that the confession was voluntary. Miller appealed the decision to the United States Court of Appeals for the Third Circuit, which is where Judge Becker came in. He authored the majority opinion for a 3-judge panel, agreeing that the confession was voluntary and affirming Miller's conviction. Judge Becker's opinion found the issue straightforward. There was no secret interrogation in this case. Indeed, the entire encounter was tape recorded. The questioning was not pressed for a long period of time, and Miller was aware of his right to terminate it upon request. He was not denied food or other necessities. Judge Becker did acknowledge one potential problem. Detective Boyce's repeated suggestion that Frank Miller needed help, not punishment. Courts had held that promises that a suspect won't be punished can defeat the voluntariness of a confession. Not in this case, however. Judge Becker explained that, although Boyce stated that he felt Miller needed help, not imprisonment, that was only part of his approach. The state court found that this questioning did not overbear Miller's will and thus did not render the confession involuntary. And this determination was supported on the record as a whole. The opinion was not unanimous. Judge John Gibbons, an outspoken liberal, authored a scathing dissent, asserting that Miller's confession resulted from an intensive, relentless questioning during which Boyce plainly and simply overbore the defendant's will. As if there could be any doubt about the severity of this debilitating examination, at the conclusion of Boyce's interrogation, Miller lapsed into unconsciousness. According to Judge Gibbons, Detective Boyce unconscionably played on Miller's unstable, childlike mind, and the resulting confession could not possibly be deemed voluntary. All of this happened before my clerkship began. I was still in law school when the U.S. Supreme Court heard Frank Miller's appeal. The court reversed the Third Circuit decision, but not because the confession was involuntary. Rather, the court decided the case on technical grounds. The court sent the case back to the Third Circuit, instructing it to reconsider the voluntariness of Miller's confession, but using a different standard. Judge Becker had believed the Third Circuit bound to defer to the trial judge's decision and to reverse only if it was blatantly wrong. The Supreme Court disagreed, holding that the Third Circuit should exercise independent judgment as if it were the first court to decide the issue. That is where things stood when I commenced my clerkship in the summer of 1985. Given the confidentiality of discussions in chambers, I would not divulge anything said even if I remembered the discussions, which I don't. But I do remember that the situation was complicated by the fact that Frank Miller was clearly guilty. Without the confession, a child murderer might walk. Judges are not supposed to consider such things, but judges are human. At oral argument, Miller's lawyer did not make things easier, more or less acknowledging Miller's guilt. The Third Circuit again found the confession voluntary in a 2-1 opinion, with Judge Gibbons again authoring a biting dissent. This time, the Supreme Court chose not to hear Miller's appeal, and that was that. Frank Miller remained in prison, and the rest of us moved on. But I did not forget about the case. During my year as a law clerk, I participated in more than 100 cases. Miller v. Fenton was one of the few that never let go, carving out a space somewhere in the recesses of my mind. Was the right thing done? Fast forward 15 years to November 1st, 2002. I was a freelance writer and had recently moved from upstate New York to the Berkshires because my wife, a music historian, landed a job teaching at Williams College. We lived next door to the Cassons. Saul, a psychology professor at the college, and his wife, who taught at the elementary school my kids attended. My wife and I scrambled to settle into our new home in a new town and her new job, and didn't have much time for socializing. I met Saul Casson just once or twice, at the tennis courts across the street from our houses, and we got no further than hello. On November 1st, I met him in the pages of the New York Times, where Saul authored an op-ed entitled False Confessions and the Jogger Case. The title and byline grabbed my attention. It is not every day your neighbor graces the pages of the paper of record. The reference to the Jogger case caught my eye as well. That case sparked morbid curiosity in me like everyone else. But I knew only the rudimentary aspects of the story. Saul's article gave more details. In 1989, 5 boys, ages 14 to 16, were charged with raping and maiming a young woman jogging through Central Park. All 5 gave detailed confessions, 4 of which were videotaped. Though the defendants recanted the confessions, jurors believed their own eyes and ears over the boys' pleas that they had nothing to do with the crime. The 5 were found guilty and sentenced to prison. More than a decade later, DNA established that a serial rapist and murderer named Matias Reyes had raped the jogger. Reyes insisted that he acted alone. No evidence linked the 5 boys who had been convicted to Reyes, or for that matter, to the crime scene. By the time the Manhattan's district attorney's office acknowledged the boys' innocence, they had served between 6 and 13 years in prison. Professor Casson's op-ed discussed this miscarriage of justice as well as broader issues. What most grabbed my attention was the claim that the way police interrogate suspects can coax the innocent to confess. Sometimes, a simple assertion like "you can't go home, you're not cooperating," could lead the accused to imagine that cooperation would bring freedom. My mind went back to Frank Miller. Detective Boyce had gone well beyond simple assertions to lead Miller to believe that he would be treated leniently if he confessed. He repeatedly suggested that Miller needed help, that he was not to blame, that he should not be held accountable. If "you can't go home, you're not cooperating" could sucker an innocent person into confessing, how about Boyce's psychological full-court press? I suddenly realized something odd. It had never crossed my mind that Frank Miller might be innocent. In fairness, it hadn't crossed anyone's mind. Not even Miller's own lawyers or Judge Gibbons so much as mentioned the possibility of his innocence. Perhaps that was partly because of other evidence of guilt besides the confession, but there was nothing close to a smoking gun. I believe everyone assumed Miller's guilt because, in 1985, not even people knowledgeable about the law took the idea of false confession seriously. The Frank Miller case had grabbed hold of me because, with the help of Judge Gibbons' passionate dissenting opinions, I had come to see problems with the way police broke down the guilty. Couldn't they have convicted Miller with old-fashioned police work, such as testing the bloodstain on his car and recovering other physical evidence, without playing on his childlike mind? Didn't they violate the spirit, if not letter, of the Constitution, which says no man can be compelled to be a witness against himself? If Detective Boyce wanted Miller's confession, couldn't he elicit it honestly, without pretending to be Miller's buddy? Reading Professor Cassin's op-ed 16 years later, I wondered whether fear of the innocent confessing had been lurking in my subconscious. At any rate, this problem, which Professor Cassin suggested was widespread, now drew me in. That was 22 years ago. Thank you for listening to this episode of the Truth About False Confessions podcast. I would greatly appreciate it if you would rate the podcast on Apple, Spotify, or whichever platform you used to listen.